If you are about to attend a family law mediation, you might have some questions about how the process works. Today, I will be addressing a few common questions about mediation. So, what is mediation? Simply put, mediation is a process whereby a mediator, who is a trained neutral third party, assists the parties to negotiate an agreement and resolve their dispute. This can happen in the same room or in separate rooms, which is often referred to as a shuttle mediation, and it can take place either in person or online. Mediation can be something that both parties agree to try, or a court might order it as part of their legal proceedings. Anything you say during a mediation is confidential, unless an exemption applies. For example, it becomes clear that there is a risk to a party or a child. What then should you expect from the mediation process? Well, every mediation is a little bit different depending on the nature of the dispute, the people involved, and how complex the issues are. The aim is always the same though, which is to find common ground in a calm, respectful environment. Often the mediator will start with a private meeting with each party before the main session begins. At the start of the mediation, both parties or their lawyers will usually make a short statement explaining what the main issues are. Mediators do not provide legal advice. Their role is to facilitate meaningful discussions between the parties. What then is the lawyer's role in the process? Your lawyer is there to support you through the mediation. They will explain your legal rights, help you understand your options, and work to reach a fair outcome. Your lawyer will also help you communicate with the other party and their lawyer, making sure your voice is heard and your needs are clearly expressed. Now let's look at your role in the process. You play a big part in the success of your mediation. Before it begins, your lawyer will help you get ready by gathering information, setting clear goals, and thinking through possible outcomes. During the mediation, you will consider different proposals and offers and decide, often with your lawyer's advice, whether to accept, reject, or suggest changes. It is important to remember that you don't have to agree to anything you're not comfortable with. If you ever feel overwhelmed, stressed, or unsure during the session, you can always take a break. Reaching an agreement. If all parties are able to agree on a solution, the terms of the agreement will be written and signed by the parties. Your lawyer will then help finalize the settlement documents, and in some cases, file the agreement with the court so it becomes legally binding. If no agreement is reached, your lawyer will explain what happens next, whether that involves more negotiation or moving forward with a court case. If you need any further assistance with your family law mediation, please feel free to reach out to the team at Solari and Stock Lawyers.